Mic check 1 2. Mic check 1 2. Mic check 1 2 3. Mic check 1 2. Mic check 1 2 3. Microphone check 1 2. Mic check 1 2 3. Mic check 1 2. Mic check 1 2 1 2 3.
Mic check. 1 2 1 2 3. Pretty loud.
Mic check 1 2. Mic check 1 2 3.
Check. Simulants.
Mic check 1 2 1 2 3. Mic check 1 2 1 2 3. Mic check 1 2 1 2 3. Mic check. Good check 1 2. Mic check 1 2 3. Good morning. This is the 9 o'clock microphone check for captions. Thank you very much.
Can y'all hear me in the room?
Yes.
Thank you.
Good morning. This is the 915 microphone check. Test 1 2 1 2 3.
Good morning, everyone. It is my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, August 2nd, 2023. The time is 9:30 a.m. With us today are Commissioners Emily Lindley and Bobby Janeka, as well as Todd Berkey from the General Counsel's Office, sitting in for Mary Smith today. For those of you who are joining us virtually, I'll ask you to please keep your microphones muted when you're not speaking. For those who will be making presentations, we will inform you of your time limits, and I'd like to ask you to refrain from speaking until Mr. Berkey or I have asked you to do so. Registration has now closed, but if you would like to address the commission on a particular item, please email agenda@tceq.texas.gov with your name, your affiliation, and the item that you'd like to speak to, and we will do our best to accommodate that request. With that, I'd like to thank everyone for being present, and Mr. Berkey. Actually, let me pause for just a moment. And I'm sorry to do this to you, but I'm going to ask our Mickey Leland interns, as well as any TCEQ employee who has joined the Office of Compliance and Enforcement within the last year, to please stand up. Would you please stand up for me? I'm sorry to do this to you. First, yeah, start there. All right, I'll let you sit down, but I want to tell you this. I want to say thank you sincerely for serving your communities, for serving your fellow Texans in our mission to help protect public health and the environment in the state of Texas. It is a meaningful mission, and your contribution is really meaningful. So thank you for that. All right, I think I'm ready to go. Mr. Berkey, please call the first item.
Sounds good. Item number 1 is a hearing request matter concerning the application by the City of Houston for a major amendment to TPDS permit number WQ0010495030 in Harris County. The parties have been notified that the commissioners will not take oral argument, but may ask questions, and this matter is before you for deliberation to decision.
Thank you, colleagues. This item features a sophisticated applicant and a single hearing request that is very clear in my mind. To cut to the chase, Mr. Hickman lives about 200 feet from the facility. His hearing request meets the procedural and substantive requirements to be entitled to a hearing, including identifying personal justiciable interests. Both the executive director and the Office of Public Interest Counsel have recommended granting the request. The applicant has not objected to that. I would go ahead and grant this request and refer his concerns about water quality, the uses of receiving waters, nuisance odors, and flooding, and do that concurrent with an ADR referral.
I'm in complete agreement.
Likewise.
If we're ready, then I'll make a motion. I would move that we grant the hearing request of Will Hickman, that we refer the application to SOA for a contested case hearing on the following issues: whether draft permits adequately protective of water quality and uses of the receiving waters under the applicable Texas surface water quality standards. Secondly, whether the draft permit contains sufficient provisions to prevent nuisance odors. And third, whether the facility, if it is located within a floodplain, is adequately protected from inundation as required by 30 Texas Administrative Code, Chapter 309, taking into consideration the applicability requirements established in 30 Texas Administrative Code, Section 309.13H and I. That we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with the SOA preliminary hearing scheduling efforts, and that we set the hearing duration for 180 days from the date of the preliminary hearing until the proposal for a decision is issued.
I second that motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Mr. Berkey, when you're ready, please call the next item.
Item number 2 is the hearing request matter concerning the application by Epitome Development, LLC, for new TPDS permit number WQ0016226001 in Williamson County. The parties have been notified the commissioners will not take oral argument, but may ask questions, and this matter is before you for deliberation and decision.
So on this one, colleagues, there are a few more moving parts, so let's just go ahead and step through it. As you know, Chapter 55 of our rules provides a two-part analysis for considering requests for contested cases on TIPD's applications such as this. First, we consider whether the requesters have met the procedural and substantive requirements to be entitled to a contested case. And assuming that at least one requester has done so, we then consider which issues are appropriate to refer for hearing. So part 1 is about who gets a hearing, and part 2 is about which issues are referred. Requesters who are affected in a manner different from the general public and who make timely comments articulating personal concerns that are relevant and material to the application and who express those concerns in a timely hearing request are entitled to a hearing. Governmental entities can have standing if they also demonstrate authority over or an interest in issues that are relevant to the application. And colleagues, we have 4 requests on this item. Patricia Daffin's request raises personal concerns that are relevant material. She resides well within a quarter mile, so I think it's likely that she would be affected in a manner different from the general public. I believe she's met all of the procedural and substantive requirements to be entitled to a hearing, so I would grant her request. Next up, we have Prairie Crossing Prairie Wastewater. Prairie Crossing Wastewater is a permittee of a facility that would be located roughly 1.5 miles from the applicant's proposed facility, but that facility, the Prairie Crossing Wastewater Facility, has not yet been built. That hearing request implicates regionalization as well as need. Also raises issues around anti-degradation and the completeness of the application. And because Prairie Crossing has not yet begun construction on its facility, but merely holds the permit, I think this is a close call. But I believe, where I would land on it anyway is that they have identified, articulated sufficiently a justiciable interest, and so I think I would lean on the side of granting that particular request. In the remaining requests, 05 Ranch Investments and Prairie Crossing Mud numbers 1 and 2, they would bootstrap their concerns to Prairie Crossing Wastewater's interests, but they don't sufficiently, to my mind, explain how they would be personally affected. So I think I favor denying those 2 requests. So let me pause there and gather your thoughts. Commissioner Lindley.
I'm in agreement. Prairie Crossing Prairie Crossing Wastewater LLC is a very tough call, and I was mostly curious to see what you gentlemen thought about it, but I can get comfortable referring them as a party.
On exactly that point, Commissioner Lindley, I found instructive the fact that the underlying statute of this area of the law that we enforce, our rules require the application to disclose existing facilities, but the underlying statute is applicable to existing or proposed facilities, referencing what we shall consider. And
Yep.
I think it would be reasonable that a court would find that, send this back. So best to move it along.
Great, thank you, Commissioner. Turning to the issues, I've identified several that I would refer, and let me step through those, and then we can consider a motion. First issue is whether the draft permit is adequately protective of water quality, including existing uses of surface water, whether it is protective of aquatic life and livestock, whether it complies with the floodplain requirements, whether it complies with TCEQ's regionalization policy, whether the applicant has demonstrated a need under Chapter 26 of the Texas Water Code, whether the draft permit adequately addresses nuisance odors, whether it complies with TCEQ's anti-degradation policy, whether it complies with buffer zone requirements, whether the application is complete and accurate, and finally, whether the notice requirements are satisfied. And just to toss into the discussion, I would also recommend an ADR referral on this item.
I'm in agreement on those issues, yeah.
I think I have a motion that would capture that.
Great.
I move that we grant the hearing requests filed by Patricia Daffin and Prairie Crossing Wastewater LLC, that we deny the hearing requests of Prairie Crossing Mud numbers 1 and 2 and 05 Ranch Investments. I move that we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with SOA scheduling efforts, And I further move that we refer the application to SOA for a contested case hearing on the following issues. A, whether the draft permit is adequately protective of water quality, including the existing uses of surface water, aquatic life, and livestock, in accordance with applicable regulations, including the Texas Surface Water Quality Standards. B, whether the draft permit complies with floodplain requirements in accordance with 30 Texas Administrative Code Section 309.13a. C, whether the draft permit complies with TCEQ's regionalization policy, and whether the applicant has demonstrated a need for the facility in accordance with Texas Water Code Sections 26.081 and 26.0282. D, whether the draft permit adequately addresses nuisance odor in accordance with 30 Texas Administrative Code Section 309.13e. E, whether the application is complete and accurate. F, whether the draft permit complies with TCEQ's anti-degradation policy in accordance with 30 Texas Administrative Code Section 307.5. G, whether the draft permit complies with the applicable buffer zone requirements in 30 Texas Administrative Code Section 309.13, and H, whether the applicant substantially complied with all applicable notice requirements. And I finally move that we set the hearing duration for the proceeding at 180 days from the date of the preliminary hearing to the issuance of the proposal for decision.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Mr. Berkey, when you're ready, please call the next items.
Items numbers 3 through 17 include the Commission's enforcement docket. The Executive Director's staff is here to present these matters. We have several individuals who have signed in who have indicated they do not wish to speak unless the Commission has questions, and their presence will be noted for the record. We do have one individual signed in on item number 12 that has indicated a desire to speak to the Commission, address the Commission. And the Commission will limit initial comments of the speaker to 3 minutes and may extend that time if the Commission needs further discussion with the speaker. And these matters are before you for your deliberation and decision.
Thank you, Mr. Berkey, and good morning, Ms. Cordell.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Michael Parrish, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before your items 3 through 17, the total assessed administrative penalties are $246,792, with $30,235 deferred, $24,441 applied towards supplemental environmental projects, and $192,116 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none at this time. Colleagues, any questions? All right, turning to interested persons. Mr. Berkey, you said there was someone here to speak to item number 12?
There's an individual signed in as Sri N. However, there's some question whether that individual is actually in attendance today. The individual did indicate they would be in attendance and not participating virtually.
Is there someone who wishes to speak to item 12, the enforcement matter concerning SAVS Management Corporation? Why don't you come forward, sir, and come up to the podium, and I'm going to ask you to check to make sure that the green light is on the microphone. If it's not, you can push the button to turn it on. And when you're ready, if you just please say your name for the record and share your thoughts with us.
Our name is Sri Neerakanda from SAVS Management Corporation. And this is regards to the underground tanks issue that we've been having for a while. Sorry. We bought this property based on saying that the tanks have been closed and there's no pumps, no nothing being operated on the premises. But we've been fined pretty heftily last year with $7,700 with no indication as to how do you control that if you all have an issue, as to what we have to do. No issue, just send us a bill saying that here is the fine. You just pay for that. And I was told today to come in here to present my case as to say what we have to do is somebody can guide us as to saying as, okay, you close your tanks, so you report this way, or whatever we have to do. But just finding a customer with $7,700 is not a joke for a small business to just survive in a business. I understand that that's your policy is to find people, but for a small business, it's tough to survive. So I just want to see what somebody can guide us or give an answer as to what we have to do.
Yeah, and I want to try to provide you with some helpful guidance, but let me understand a little bit more about the facts and what you're asking about. I believe it's the case that that SAVS Management or SAVS Management Corporation has entered into an agreed order on this, and that agreed order includes both a penalty component, but also I suspect it includes some ordering provisions that provide some instructions, maybe not detailed instructions, but some instructions that require the facility to come into compliance. And I think what I'm hearing you say, and you correct me if I'm wrong, but I think I'm hearing you say that you're not contesting what has already been agreed to, even though you're registering that it is a significant penalty and you feel that, but you're not contesting it. You're just asking for guidance about what exactly do we need to do to come into compliance with this order. Do I have that correct?
Yes, sir. We already paid for the fine, so
Okay.
I mean, the money is gone. So just don't want to have the same issue coming again next year or this year,
Right.
where we have to pay an FT fine again.
Right. We have a small business and local government assistance program that provides compliance assistance to people who are exactly in your situation. And I think you could probably find their phone number on the web pretty easily. If not, I would invite you to call my office. I'm also easy to find, and we'll make sure to put you in touch with that program to get you whatever advice that you'll need in order to come into compliance. Does that work for you?
Yeah. I mean, as I said again, I mean, I know if a chance is given to a small business, I'm sure somebody will just go ahead. But rather than just sending a bill saying that you owe so much of money, and we bought this building from a previous owners, thinking that there was no business being done in that location, so everything has been shut down. But just asking us to pay so much money and saying that if you don't pay, we're just going to go to the courts is not how a small business can run business.
Yeah.
But I appreciate your time, and that's my main thing. I mean, a little guidance as to where we need to register or, do our way as to meet your requirements will be great.
Okay, well, I'm
Yeah.
very sympathetic to what you're sharing with us, and if you have any trouble reaching the people in our small business and local government assistance program, please let my office know, and I'll make sure that we make that connection.
I appreciate that.
All right, thank
Thank
you
you.
very much, sir.
Thank you.
Mr. Berkey, is anybody else signed in to speak?
No one else is signed in to
Okay.
speak.
Let's hear next from the Office of Public Interest Counsel. Good morning, Mr. Arthur.
Good morning, Chairman and Commissioners. For the record, I'm Garrett Arthur, TCEQ Public Interest Counsel. OPIC supports adoption of these enforcement orders as presented by ED staff.
Colleagues, I do as well. I think I'm ready for a motion.
Well, I would move that we adopt items 3 through 17 as recommended by the executive director.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Mr. Berkey, when you're ready, please call the next item.
Item number 18 is the consideration of the adoption of new Title 30 Texas Administrative Code, Chapter 338, regarding the above-ground storage vessel safety program. The Executive Director staff is here to present this item. We currently have one person who has signed in on this matter that has indicated they would like to address the commission. The commission will limit initial comments from each speaker to 3 minutes, but may extend the time if the commission needs further discussion with that speaker. And this matter is before you for your deliberation and decision.
Thank you, Mr. Berkey, and good morning, Mr. Sheedy.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Keith Sheedy of the Critical Infrastructure Division. With me is Bill Shafford with the Office of Waste, Haya Simon with the Occupational License and Registration Division, Barrett Hollingsworth with the Litigation Division. This adopted rulemaking will add a new Chapter 338 to implement SB 900 from the 87th Texas Legislature, required the establishment of a site-wide above-ground storage vessel program. The proposed rulemaking was published in the March 10th, 23 issue of the Texas Register. 6 public hearings were held between March 23rd and April 10th in Fort Worth, Beaumont, Houston, Corpus, Midland, and Austin. And the public comment period ended on April 10th. Based on the comments received, the rule team made changes while staying within the intent of SB 900. However, many of the comments received were outside of statutory language found in SB 900. The most significant change made from received comments concerning the applicability of the standards. Section 338.1B and 338.5A were revised to include language to clarify the applicability of the rules applied to ASVs, and the standards are only applicable when both the vessel meets the definition of above-ground storage vessel and the ASV satisfies the applicability criteria in the listed standard. This change clarifies that it is not the intent to expand the applicability of the standard beyond the applicability provided in those specific standards. It should be noted that the proposed incorporation by reference of 40 CFR Part 264, the record standards, was removed. Reasoning being that after further review, it was determined that there should not be any ASVs that would be subject to both the Chapter 338 rules based on the definition of regulated substance and the listed hazardous regulations. Therefore, these standards have been removed and an exemption was established in 338.3. Also, the definition of regulated substance was revised to clarify that ASVs containing a mixture of 1% or greater by weight of a regulated substance, the total mixture would be considered to meet the definition of a regulated substance. In conclusion, staff respectfully recommends adoption of the rulemaking to Chapter 338. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you, and we're here to answer your questions.
Thank you, Mr. Sheedy. I have none. Colleagues, any questions?
I don't have any questions, just two quick comments. Anyway, I'll just jump to them. Even though I just want to give kudos, first and foremost, for all the work that's gone into this. A brand new program is a very big undertaking. So thanks to y'all for hosting all the public meetings. Thanks for being so diligent and trying to fulfill, what the ledge is now requiring us to do. I do just want to say, I know there is a cap, $2,000 cap limit on the fees. This program's new. If in a couple years, and I don't expect we will know for a couple years what it's really going to look like and what the workload is really going to look like. If we need to work on tweaking that fee so that we have the money to run the program, we got to do that, and you got to let us know, because I don't want us to get into a pickle later down the road where the fees aren't there to fund the program, and our investigators or people in Haya's world aren't getting paid what they should get paid to do the work. So just, don't be scared if you need to come to us and say, we need to reevaluate this fee structure. And then secondly, because this is so new and it's so technical, I hope that the guidance document will be, really productive and really helpful for all those involved. There might need to be changes that need to be made along the way, and it's harder to do that in a rulemaking. So, whatever can be done in the guidance document that makes it easier for people to understand, especially the people that are going to be regulated. Don't be scared to make changes here and there. I just want this to work for everyone, and I want it to be digestible for the public. So anyway, I know y'all will do that. I'm just saying it here and now while it's on my brain, but I really appreciate all the work y'all have done, because this is a big deal. So thank you.
Commissioner, it is a big deal, and thanks for your comments. And I had both of those thoughts in terms of the guidance document. I think that this rule does a very good job of meeting the legislature's intent in a way that's practicable, but it does leave quite a few questions unanswered about how it will be implemented. And I think a guidance document and then just the practice of implementation will answer those questions. I also had the same thought about the fees. I understand that that current projections and estimations are that we are well within that $2,000 statutory cap, but we have had staffing issues at this agency, connected to salary dollars, and we need to make sure that we can pay our employees to do this work. I think we're okay now, but I had both
That's
of
in the
those,
future. Yeah,
I had
hopefully
both of
that's a
those
long time
thoughts, and I
away.
appreciate
Yeah.
you bringing them up. Commissioner Janetka, any questions or comments for staff at this point?
Thank you both for those comments. I wanted to sharpen the point that I think you both made in touching on the fees and the forward-looking nature of how we're making some assumptions, and I hope that we will watch it closely. There is a piece that I understand in there hopefully reflects a bit of an overestimate in the terms of the staff need and the impact in the regulatory universe where this may land. We've made some good guesses on how many asks will come from the public for these particular types of facilities through this new authority. But to the point of the guidance document, this begins a conversation that I hope we will have in an ongoing manner with both the public and the regulated community all around the new expectations that our agency is thoughtfully carrying forward at the direction of the legislature. Nothing to add right now.
All right. Thank you, Commissioner. Thank you, Mr. Sheedy. Mr. Berkey, you said that there was someone who had signed in wishing to address the commission.
Upon clarification, that individual does not wish to address the commission. The individual's presence will be noted for the record, though.
Thank you. Let's hear next from OPIC. Good morning, Mr. Martinez.
Good morning, Chairman, Commissioners, General Counsel, and Executive Director. I'm Eli Martinez with the Office of Public Interest Counsel for the record. Our office participated in this rulemaking, and we are satisfied that the adoption package before you serves the public interest by creating the above-ground storage vessel safety program to provide for the protection of groundwater and surface water resources in the event of an accident or a natural disaster. The rulemaking is statutorily required and was specifically assigned to our agency. We noted the comments that were made during the rulemaking efforts, and we agree on the disposition that was arrived at by the team, both in instances where changes were made in various definitions or even in the exemption of vessels that were already federally regulated, but also in instances where no action was taken, such as maintaining the hard certification date of September 1st, 2037, and declining to adopt standards that veer too far from SB 900. And for these reasons, we support adoption, but we are available for any questions.
Thank you, Mr. Martinez. I have none. Colleagues, any questions for OPIC?
No, thank you.
All right. Well, as I mentioned a moment ago, I think that this rulemaking package does faithfully implement the statute. I'm ready to adopt it.
I am too.
I move that we adopt the new sections of 30 Texas Administrative Code, Chapter 338, as recommended by the Executive Director.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Mr. Berkey, when you're ready, please call the next items.
Item numbers 19 through 22 are the quadrennial rule reviews for Title 30 Texas Administrative Code, Chapters 80, 122, 218, and 305. The Executive Director's staff is here to present these matters. No one is currently signed in to address the commission on these items, and the matters are before you for deliberation and decision.
Thank you, Mr. Berkey and Ms. Rico. Good morning.
Good morning. Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Gwen Rico with the General Law Division. Pending before you are items 19 through 22, the adopted rule reviews of 30 Texas Administrative Code, Chapter 80, Contested Case Hearings, Chapter 122, Federal Operating Permits Program, Chapter 218, Brine Evaporation Pits, and Chapter 305, Consolidated Permits. As required by Texas Government Code Section 2001.039, Executive Director's staff conducted a rule review of these chapters to determine if the need for the rules within these chapters continue to exist. The proposed notices for the reviews for 30 TAC Chapters 122, 218, and 305 published in the February 24th, 2023 issue of the Texas Register, and due to an issue with the online public comment system, the comment periods were extended from March 27th to April 14th, 2023. Chapter 80 published in the March 24th, 2023 issue of the Texas Register with a 30-day comment period. One comment was received on Chapter 122 Rule Review Project, and this comment was reviewed and determined to be outside the statutory and regulatory purpose of the rule review and will be considered when the rule is next substantively changed. Based on the review of these chapters, the Executive Director has determined that the reason for the rules in Chapters 80, 122, 218, and 305 continue to exist. In conclusion, we respectfully recommend approval of the adoption of the rule reviews of 30 TAC Chapter 80, 122, 218, and 305. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you. The project managers and attorneys assigned to these chapters are here with us to answer any questions.
Thank you, Ms. Rico. I have none. Colleagues, any questions?
No, thank you.
No questions, only to note that I'm grateful that this quadrennial rule review process continues to offer opportunities for the public to provide comments that, while aren't relevant and germane to that question we're asking, are these worth continuing on? Yes, clearly we want to keep our contested case hearing process in rule, but I'm grateful, and I reassure the public that our staff do receive those comments and then review them as those rule chapters come up in appropriate times.
Thank you, Commissioner. Mr. Berkey, I'm going to have you repeat yourself. I think you told me there's no one signed in to speak on this.
No one has signed in to speak on these
Okay.
items.
And Mr. Arthur, what does OPIC think?
OPIC agrees that the reasons for initially adopting the Chapter 80, 218, and 305 rules continue to exist, and we support readoption of the rules in each chapter. Regarding Chapter 122, it is OPIC's understanding that EPA's comments will be considered as general stakeholder input for possible future policy or rulemaking actions. With that understanding, OPIC agrees that the reasons for initially adopting the Chapter 122 rules continue to exist, and we support readoption of the chapter.
Thank you. Colleagues, I agree with Ms. Rico and Mr. Arthur. I'm ready to move forward on these items.
And so I can make a motion and hopefully say it the correct word this week. Adopt the rule reviews and readopt the rules in 30 Texas Administrative Code chapters 80, 122, 218, and 305 without amendment as recommended by the Executive Director.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Mr. Berkey, please call the next item.
Item number 23 is the public comment session. We currently have one individual that has signed in and expressed an interest in participating in that. So the commission will receive comments from the public on any matters within the jurisdiction of the TCEQ in accordance with Texas Water Code Section 5.112, except for pending permitting matters or other contested cases, which are subject to the ex parte prohibitions found in Texas Government Code Section 2001.061. The commission will limit initial comments to 3 minutes, but may extend that time if they want further clarification from the public commenter. So with that, I'll call Jojo Hesselmeyer.
Good morning, Ms. Hesselmeyer. Good to see you.
Good morning. How are you?
Good, doing well, thank you.
Good,
I'll ask you just to go ahead and reintroduce yourself for the record, and then we're happy to hear from you.
Will do. Good morning, Commissioners. For the record, my name is JoJo Hazelmeyer, and I am the Deputy Executive Director for the Texas State Inspection Association. Prior to joining TSIA last August, I spent 32 years at the Texas Department of Public Safety, where I retired in 2020. Of those 32 years, over 20 of those I spent managing the Vehicle Inspection Program as the Service Director over the Compliance and Enforcement Service. Today, I want to discuss two main concerns related to the Emissions Inspection Program. The first is the gap between safety inspections, when safety inspections end in Texas, and when emissions testing has to begin in Bexar County. The second is the emissions inspection fee. With the passing of HB 3297 this legislative session, all non-commercial vehicle safety inspections will go away January 1, 2025, along with the $7 fee stations currently collect for performing that safety inspection. If emissions testing in Bexar County doesn't start until November 7th, 2026, there will be a 22-month gap where vehicle inspection stations will be forced to shut down their station, and certified inspectors will have to look for other employment. TSIA's recommendation would be to implement emissions testing in Bexar County closer to the January 1, 2025 date. Our second concern is the emissions inspection fee set by this commission. This is a statewide issue, not just a Bexar County issue, but because you will soon be taking action on the Bexar County program in November, I would like to ask that you examine this issue closely. Keep in mind, emissions inspections are performed by private businesses, and these small business owners have to make a decision about whether it makes good business sense to offer emissions tests based on the cost of their equipment, rent, and the revenue that will be generated from the inspection fee. In 2001, the Texas legislature required TCEQ to review the fees established for the motor vehicle emissions inspection program at least biannually. Your agency conducts this study every 2 years, and each time it has recommended that the fees should be increased. Additionally, in 2020, TCEQ commissioned a study to help prepare for the future implementation of an IM program in Bexar County. This study recommended a fee between $18 and $22. Based on these two studies, which were done prior to the significant inflation that we've all seen these last 3 years, TSIA recommends a standard fee for all emissions testing in Texas be set at $25. There's not a single service that you and I pay for every day that has not increased significantly in the last 20 years. Yet the emissions inspection fee has never been increased, not since the inception that I'm aware of, since 2001.
That's 3 minutes.
Okay.
I'll just ask you can finish your thought.
Okay. So for those citizens who have to take off of work to get their emissions inspection done, it'll cost them more in lost wages than it would to increase this fee. Again, it's my personal and professional belief that HB 3297 will be the straw that breaks the camel's back come 2025. I urge you to heavily consider these recommendations, and I'm happy to answer any questions that you may have.
Thank you, Ms. Hazelmeyer. Appreciate you being here today. I don't have any questions for you. I'm going to consider your comments offline. Thank
Okay.
you.
All right. Thank you.
Appreciate you.
All right. Thank you, guys.
Mr. Berkey, anybody else wishing to address the
No one
commission?
else has indicated an interest in participating in the public comment session.
Okay, with that, I'll ask you to please call the next items.
Sure. Items numbers 24 through 27 are posted for closed session, and the commission will not meet in closed session today.
With that, the time is 10:07 a.m. and we are adjourned.